I'm giving 5 minutes to get them to start and join. So at 4:05, the class is going to start. So kindly inform them that I'm giving them extra 5 minutes to get their things together. At 4:05, the class is going to start. All right. So good evening once again. I'm going to start, and then if your colleagues are able to join, we continue with them. All right, so as of last week, we went through the concepts of the Ghana legal system itself. We looked at what constitutes business law, and then we also looked at the sources of business law in Ghana. Today, I'm just going to take you through what we did last week, and then we'll continue from where we left off. Now, if the network is okay and everyone can hear me, can I see a thumbs up? Just give me a thumbs up to verify that you can hear me and then the network is okay. All right. So we went through the definition of business law and we said it is the branch of law that governs business and commerce. Now, these are related business laws and each of them has its own part. Now, we mentioned that Ghana's laws have been heavily influenced by the common law. So there are some laws that do not have a acts in Ghana that governs it. That means that we still rely on the common laws principle or the common law principles to help us guide in navigating these laws. And there are some laws that have also come up with some legislations, but with those acts, we go with them if it contradicts the 90, if it contradicts the common law. So even with the area of commerce that we've developed a legislature in that respect, we can still rely on some common law principles. So we can rely on common law principles when we are dealing with matters in relation to that specific area. However, if the that's if an area is not provided for in the common law or it contradicts with the Ghana's legislature, that is where we come back to our original legislature. So there are some laws that we use them concurrently. We use the Ghanaian Act and then we use the common law and then we use them concurrently. However, when they contradict, then we'd have to go with our Ghanaian legislature. But have it in mind that Ghana still relies on a lot of principles that came out of the common law. So, for example, when it gets to agency law, Ghana doesn't have a standalone agency act. We rely mainly on the common law principles, and some of the relationships are also governed by the Ghana's Contracts Act. Sale of Goods Act, even though we have an Act, Sale of Goods Act of 1962 Act 137, we can also rely on the common law principles. But the main act is the Sale of Goods Act. But we rely on some of the principles that we got from the common law. All I'm saying is that if the common law does not contradict the Sale of Goods Act, then we can go with that principle. It is only if the common law contradicts the Act of Ghana that is where we would have to now switch and then solely use the Act of Ghana. Carriage by land is also governed by common law principles supported by the Contract Acts. We have carriage by sea, where we have the Bill of Lading, the Merchant Shipping Act. Terms of guarantee is also governed by the common law supported by the Ghana's Contract Acts. Insurance is governed by the Insurance Act 2021. Now, when you take a look at your book, it's referred to the old laws of insurance. So, in business law or in law, sometimes there are some amendments and there are some laws that come out. There are some laws that have been replaced. So, sometimes the books that code provides, it may need some updates. So, until the next time that they update, sometimes some laws are still there that need some updates. So anytime that I come across such a law, I'm going to make you aware that this law is an old law and it has been replaced by a new law. Or if there has been some additions or amendments, I'll let you know. So the Insurance Act that you see in your books has been replaced by the Insurance Act of 2021. So I want you to take note of that one. Also, the Bill of Exchange law is governed by the Bill of Exchange Act. Partnership law is governed by the Incorporated Partnership Act. Company law is governed by the Companies Act of 2019. Employment or labor law is governed by the Labor Act. Criminal law is also governed by the Criminal Offence Act of 1960. We also have Higher Purchase Acts governed by NRDC 292 of 1974. Conditional sales is also governed by the Higher Purchase Act. And then we have tort law. Law of thought is also governed by common law principles, so mainly by the common law principles. Land law is governed by the Land Act 2020. Bill of Lading is governed by the Bill of Lading Act 1961. We also have the law of trust, which is governed by the Trustees Act, also supplemented by the common law. And then we have negotiable instruments governed by the Bill of Exchange. Now, there are some laws, as I mentioned, we'll be treating some laws, we will not be treating. So, some laws are there that we'll be treating in this business law, we'll be treating contract, we'll be treating agency, we'll be treating sale of goods, and we'll be treating a bill of exchange, insurance, partnership, and company law will be treating it. Please hold on, I'm coming. Sorry about that. Tort law will also be treated. However, there are some laws that will be treated because of how separate your programs are. So, for example, employment law will be treated by those who are in HR. We can also have company law. I think company law is being treated by accounting, finance, and also I think a whole number of businesses also be treating the company law, as they say, the company and partnership law. So these are business laws, and in respect to where you specialize, you'll be treating most of these laws, but not everyone will be treating all of these laws. Now, we've already covered this concept of law where I said that the prominent ones are the positivist and the naturalist. And the positivist, they believe that so far as a law is coming from someone who has a recognized authority, then that is a law. And then the naturalists believe that law should always go with morals. So they believe that if something is morally good, then it becomes a law. If something or a statement is not morally good, then it should not be regarded as a law. So we've already gone through all of these. The proponents of them, including John Austin, Professor Hart, and Professor Hans Kelsen, we've treated all of these. So let's just skip over it. After that, I'll send this to you so that you read it. Now, we also looked at the system of laws. System of laws. And I said that when we are talking about legal systems, then we are mainly talking about the common law system and then the civil law system. Common law system were based on judicial precedents and decisions. They were based on judicial precedents and decisions. And they mainly originated from England. They mainly originated from England. And civil law usually deals with codified statutes. So they were dealing with codified statutes, and it originated from other European countries with roots in the Roman law. Now we have classifications of law. We've already gone through this. We did substantive law versus the procedural law. So substantive law creates and controls the rights, whilst procedural law creates the process of enforcing those rights. So an example of a substantive law is the Criminal Offence Act, and an example of the procedural law is the Criminal Procedural Code, showing us how we should apply the law if someone is arrested, how the person is arraigned, how the person is prosecuted, how the person appears before court. All of these things are there in the Criminal Procedural Code, while the substantive law is telling us what is a crime and the punishment for those crimes. Next, we go to private laws and public laws. Now, private laws involves relationship between two individuals or among individuals. So the citizens, the laws that regulate us are known as the private laws. And then when it comes to public laws, it involves the government and its citizens. So anytime that there is an issue being resolved between government and the citizens, then we are looking at the public law. So an example of private law is law of contract. An example of public law is the constitutional law, criminal law, and then we have the tax laws. So all of these are examples of the public law. Next, we go to criminal law and the civil law. Now, this shows how an issue is handled in courts. So criminal laws, when it gets to criminal laws, it just controls the wrongdoings and it leads to someone being punished. So anytime that we're talking about criminal law, it controls wrongdoing against the whole society itself. So even sometimes, even if the wrongdoing is against a person, the government is going to take it upon himself and then prosecute on behalf of that person. An example is rape. You know that generally when someone rapes, the person doesn't rape the government itself. However, it's a criminal issue. So when someone rapes someone, the government is going to take it upon himself and then prosecute on behalf of that individual. Amnesia, you understand?
Yeah, please, I'm trying
Amnesia, you
to
can
find
unmute
out
yourself.
where exactly you are. Please, can you kindly tell me where exactly you are reading, like the unit or session you are?
We are still in unit one. This is present in unit one. This is present in
All
unit
right, thank
one.
you very
We've
much.
already gone through this, but I'm just reviewing it for you. We've only gone through this
Oh,
last
okay,
week, but
all right.
last week my network, the network wasn't good for us, so I'm just recapping for those who didn't hear me properly.
Okay, okay, all right. Thank you
All
very
right,
much.
but if you want all of these, just look at page six. Page six of the book, you find it there. All right.
Okay, all
So,
right.
like I was saying, criminal and then civil law, it shows how a case is being handled. So, criminal, it seeks to persecute. Criminal seeks to persecute for a wrongdoing. It seeks to persecute for a wrongdoing. So, for example, when you rape someone, the government is going to take it upon himself and then persecute you. Prosecute you. And then civil law is concerned with private rights and remedies. Private rights and remedies. So this gives private rights and remedies. So usually we say that the private law is actually the private law usually goes to the civil law procedures when we are dealing with private law. So this is contracts it is. Now we can also contrast international with domestic laws. International with domestic laws. All right. I think my network went off. I don't know. There was something obstructed. So, what was the last thing that you heard? The last clear sentence that you heard? Anyone? The last clear sentence that you heard?
So I think it's criminal law. Criminal law.
Hello?
So you can.
Pause. Are you online? And it doesn't matter even if you do something. All right. Thank you. It doesn't matter even if you do something against the individual. If it's a crime, then the government is going to prosecute on their behalf. So that's what the criminal is. It seeks to look at crime and how crime is being punished. But however, sometimes some things can be criminal and civil at the same time. You can do something to someone, the government is going to prosecute and you'll be punished, and also the person that you did the thing to can also sue you to gain compensation. So some actions can constitute both criminal and then civil issues. But anytime we distinguish the criminal aspect from the civil aspect, even though it is one action that is causing the person pain, we can distinguish the criminal from the civil. Criminal is because you have actually breached a crime or you've committed a crime and the government is going to take you on and punish you. And then the civil aspect is going to be that you've hurt the person. And because you've hurt the person deserves some compensation. So one action can actually result in both criminal and civil cases. Both criminal and civil cases. For example, if you assault someone, or even if you rape someone, after you are being persecuted, there can be civil remedies to the person who has been raped. So sometimes an action can have both criminal and then civil remedies. All right. So moving on, we move on to international versus domestic laws. Now, international laws regulate relationships between nations or among nations, whilst domestic laws operates within a jurisdiction. And then we have common law as against statutes. Common laws are judge-made laws, while statutes are passed by the legislative arm. Common laws, judge-made statutes are passed by the legislative arm of government. Now, we looked at the functions by classification, where I said judicial function, where there is interpretation, and then they also help adjudicate disputes. Legislative is to determine what rules go to govern us, and executive is where we enforce the law to ensure peaceful behavior. Now, generally, the functions of law will include defending us from evil, promoting the common good, resolving disputes, and also compelling obedience of law and order. Now, we also moved on to the evolution of the common law. Quickly, let me just go through this. Now, the common law, when the British were being, when the British came to their settlement, that's the English, where they were settled, they were using local laws in each part of where they were. So everyone was using their own local laws. But then the king would send, so when King William came, he would send judges across, and then they will still adjudicate using the local laws. However, when they came back, they will have a conversation among themselves and they will discuss which laws were right and which laws were wrong. So they decided the laws that were wrong would just be dropped, and then the laws that were right would be kept. So as they were doing that, they came to have a unified law that binds all areas in England. So a common law was being applied commonly in the whole area. So it was common to everyone in that jurisdiction. That is how the name common law came to be. Now, so the various rules developed became common and were exported around the world to the Commonwealth countries. Before already covered that, where now Ghana heavily influenced by the common law. Now, by the 12th century, common law court has been established to apply the common law. Royal writs were given to begin civil actions. Every writ were applied for a specific cause. Also, litigants had to fit their circumstances to one of the available type of writs. So this was how they were applying the common law. However, the common law were given unjust rulings. So there were some weaknesses in the common law that necessitated they coming out with the court of equity or laws of equity. Now, the weaknesses of the common law system. If a case did not fit if the case did not fit a specific type of rate, then there was no way you could bring that case to the law court. That means that if your case did not fit the available rates that they had, the orders, or it did not fit the way that you are going to apply in order to get into court, then it will be impossible for you to bring the case to court. Also, if you use the wrong rates, they'll just throw the case out of court. So if they find out that you've used the wrong rate, they'll just throw the case outside of court. Also, the common law did not recognize beneficiaries' rights under trust. It only recognized the trustee as the legal owner of the trust property. As I've already tweeted last week, where I said an uncle and a nephew, when a father leaves an item in trust of the nephew to the uncle, when he becomes of age, the uncle can decide not to give it back. And even if he sues in the common law is only look at the property, the ownership of the property at that particular time. The common law will not recognize the beneficiary's right under a trust agreement. And also, the only remedy available was damages, monetary compensation. Now we know that it is not every time that money can be used to compensate someone. There are some things that when it happens, you need more than money to compensate you. So these were the weaknesses of the common law system. That led to the emergence of the court of equity. Now, under the court of equity, people will bring their grievances to the king, and the king is going to just divert it to the chancery. So that led to the creation of the court of chancery, which is also known as the court of equity. Now, the court of chancery will apply equity based on many sources, such as the Roman laws and also the natural laws. Natural laws, like I've already mentioned, look at good versus evil. So you look at what is good, what is moral, and what is immoral, rather than to apply only the common law to achieve a just outcome. So the chancery was looking at achieving a just outcome and not just following previous decisions made by other judges. Now, the chancellor also did not apply a rigid rate system, where if you don't find a rate, you cannot apply, or even if you began with a wrong rate, your case will be thrown out of court. Now, in the court of equity, proceedings began with a bill being presented by the plaintiff in a vernacular language. So they had their own languages. It was not compulsory that you have to submit in the official language. Now, the defendant will be summoned with a subpoena to appear for personal questioning. If they did not appear, then their punishment was imprisonment. Equity also created additional remedies like specific performance and injunction. These remedies, will be discussing them in contract later. So when we get there, I'll discuss them to a larger extent, but know that they added additional remedies beyond the cash compensations. Also, equity created additional remedies and also recognized interest of a beneficiary under a trust. The Chancery did not follow binding rules, relying entirely on the Chancellor's view of what was right and what was wrong. Now, features of the Court of Equity, they focused on fairness and justice. They did not rely on rates. They recognized beneficiary interest in trust, and also they introduced remedies such as injunctions and specific performance. I'm rushing through this because we've already done this, and we did it last week. Now, the Court of Chancery became very popular. This caused some resentment among the common law lawyers who argued that the quality of decisions was dependent on the quality of the chancellor. So they became better and they were saying that since they did not follow any laid out procedures, it was just based on the quality of the chancellor. So if the chancellor is a good chancellor, then that means that his argument for good will be good and his argument for bad will be bad. But what if the chancellor is not someone who is of that quality? So they were saying that the decisions were dependent on how quality the chancellor was. Also, because precedents were not followed, each case were considered on its merits. So every case were considered on its individual merits and not based on previous decisions. Now, conflicting judgments of the common law court and the chancery were referred to the court. So because they had different courts, if you get two different judgments from the court, common law court and the court of chancery or the court of equity, they will send it to the king. And the king made a proclamation that any time that there's a conflict, equity should prevail. So anytime that there's a conflict, then it means that the court of equity prevailed over the common law rulings. Now, moving forward, the rivalry continued by gradually reduced because equity began to be ruled by precedent and standard principles. As equity took the shape of common law with recognized principles and precedents, the Judicature Act was passed and it provided equity and common law to be administered by all courts. Now, they did not fuse the laws together. However, they said that every court can just administer both the court of the laws of equity and also the common law system. So there's still a body of common law which is distinct from the common law system. Now, the same court can administer both. Equity created maxims which had to be satisfied before equitable rules could be applied. So you could look at the maxims of equity. I've already asked you to do that. We have a lot of maxims of equity, and they created that, and they said that a case should, or everyone who is coming should make sure that the maxims are satisfied before each corresponding rules shall be applied. So, for example, one that we have here, equity follows the law but not slavishly, which means that they will first apply the common law, but if the common law would lead to injustice, then they would now go on to the courts or the laws of equity. Another one, as I've already mentioned last week, that he who comes to equity must come with a clean hands. That means that if your hands are not clean, you do not qualify to be judged with equity. So he who comes to equity must come with a clean hands. That means that before you come accusing someone of doing something bad to you, you must make sure that you yourself, you've not done something bad to the person, or you yourself have not committed any bad thing. Other ones can include he who comes to equity must do equity. You are accusing someone of not holding on to their end of the bargain. Whilst you yourself, you've not done your part. So that's why they said that they created a maxim and they made sure that you have to satisfy the maxim before equity rules could be applicable to your case. Now we move on to judicial precedents. Judicial precedent. Now, judicial, I think this was where we ended last week, right? Hello, who remembers where we ended last week? I think this was where we ended last week. Yeah.
Yes, sir.
So judicial precedent. Now, judicial precedent means the process whereby judges follow previously decided cases where the facts are sufficiently similar The key word is sufficiently similar. That doesn't mean that they can apply previous decisions to every case that they see. They must just make sure that the case or the facts of the case are sufficiently similar. Now, this system of precedent is based on the Latin maxim "stare decisis aeque quibet movere," which means that what has been decided and stand by what has been decided and do not unsettle the established. That means that if something has been established, you have to stand by it and do not unsettle the established precedent that has been given already. Now, this means that lower courts are bound to apply legal principles by superior courts in earlier cases, whether the judge in the lower court agrees or doesn't agree. So far as a superior court has given a decision that on a similar case, they must apply that same decision to the similar case in front of them, even if they disagree with that precedent. Now, this provides certainty and predictability in the law. That means that you yourself, as a person, as a lawyer, or as an individual going to court, before you go to court, you know the probable or the possible outcome that you are going to get, because there has been cases that have been filed already. So if you find yourself in an instance, you know the cases that surrounds it, and because of that, you can use that to advise yourself whether to move forward to court or not to move forward in court. Now we have parts of a judicial decision. Parts of a judicial decision. Now, the decision of the court can fall within two parts. We have the ratio disadendi and then obiter dictum. The ratio disadendi is the reason for the decision. This is the binding decision. And then the obiter dictum are statements that are made in passing. These are just persuasive, but they are not binding. So when the judge is making the decision, he's going to tell you the reason for his decision. Those ones are binding and should be followed. However, the obiter dictum, they are just statements or speculations or even comments that he's just making in passing. Now, these are persuasive, but they are not binding on the lower court. The lower court can follow that advice in their ruling, but it is not binding on them. However, sometimes when the judge in the superior court is coming up with a decision, he or she may not explicitly tell you which one is the ratio disadendi and which one is the obiter dictum. So this is what creates a little bit of confusion. Sometimes they may be clear in their statements and tell you that this is the reasoning and this is just mere statements. But sometimes they may not be explicit. And navigating between which one is binding and which one is persuasive can be a little bit difficult. So that's also a disadvantage of the judicial precedent. So difficulties may arise because it is sometimes difficult to determine what is a ratio disadendi in a case. A judge in a decision would not state that this is a ratio disadendi, and it will be left to the judge in a later case to elicit that. So sometimes it may be a little bit difficult. Sometimes they may be gracious enough to tell you which one is the reasoning and which one is just the persuasive comments. However, sometimes they may just make all together, they may just make all the comments together, which might make deciding which one was the ratio disadendi and which one was the obiter dictum. It may be difficult to explain between the two of them. Now, judicial precedents and lower courts. Like I've already mentioned, a lower court may not rule against a binding precedent, even if it feels it is unjust and wrong. So as a lower court, so let's bring it to Ghana's court structure. If the Supreme Court gives a ruling, every subsequent court must follow the ruling of the Supreme Court. Even if you believe the decision is wrong or the decision is unjust, you just have to apply the principles to all similar cases from there on. Now, you may only express the hope that the higher courts or legislature would reform the rule in question. So you may hope or you may have a comment that you feel like this is bringing about injustice. So you hope the higher court amends it, or you hope there's a legislature or there's a law to amend it. But even in that comment, you still have to apply the rules that the higher court has given you or the higher court came out with when they were having their decision or their precedents. However, if the judgment goes to appeal, the appellate court will have the opportunity to review both the precedent and the case under appeal, perhaps overruling the previous case law by settling new precedent of a higher authority. So if the case go for an appeal, in Ghana here, the Supreme Court is the highest court, so it cannot go for an appeal. So let me use the High Court as an example. If the High Court gives a ruling, it is binding on all lower courts. Now, even if the lower courts feel like the case is unjust, the lower court must apply it. However, if the lower court gives a decision in line with the precedents and it moves on to the Court of Appeal, the Court of Appeal can now say that they are doing away with the decision made by the High Court because the Court of Appeal is higher than the High Court. Now, this may happen several times as a case works its way through successive appeals. However, when the appeals reaches the Supreme Court, that is it. When the appeal reaches the Supreme Court, that is it. The decision made by the Supreme Court is final, unless they themselves would want to review the case. Unless they themselves would want to review the case. However, so let me put it this way, generally, all decisions made by the Supreme Court are final unless they decide that they will review a decision that they've taken. Now, quickly, a review is where they can decide that there may be an error in the case that they've decided previously. So they are going to sit on it and decide whether they are going to maintain the original precedents or they are going to go away from the precedents. Now, we move to types of precedents. We have original precedent. This is a point in law that has never been decided before. So the judge who decides it, that becomes a new precedent, that becomes an original precedent for later cases to follow. And then next, we go to binding precedents. Binding precedents, as I've already mentioned, these are precedents that you cannot do away with. Precedents that you cannot do away with. And then we have the persuasive ones, the other comments that are made in passing. Now, these are not binding on the court. However, a judge may consider such precedent and decide that it is a correct principle to follow. So examples are decisions by a lower court in the hierarchy or a decision made by a foreign court. So sometimes there may be a decision made by the district courts, and then a similar case will go to the high court. Now, if the district court came up with a decision, it is not binding on the high court because the high court is higher than the district court. Now, so the high court looks at precedents given by the district court as persuasive. They may agree with it when they feel like it is true and then it must be taken into consideration. However, it is not binding on the high court for the high court to actually go by the decision made by the district court. Also, when it comes to decisions from a foreign court, they can compare the foreign court and compare it to Ghana and look as to whether if they import the decision, it will be suitable and it will go and give and it is going to give us the right decision. If they feel like it can do that, then they can import a decision from a foreign court and then apply it on a similar case in Ghana. So we move on to the advantages of judicial precedents. Advantages of judicial precedents. Now, it is practical. That means that subsequent decisions are on actual cases and not just theory and logic. Always, if there has been an original precedent, always you can just follow it and then use it to solve similar cases in the future. It is not always that you have to apply from theory or you have to use your logic in order to come up with a decision. Two, it ensures impartiality of judgments or judges. That means that it doesn't matter what the lower court judge feels. If there has been a decision by a superior court, they must follow it. And that reduces impartiality of judges. Also, it avoids mistake. The precedents are already there. So just pick the principle and then what? Apply to the similar case that you have. It helps reduce mistake in that regard. Also, it brings certainty. Before you go to court, you most likely know what you are going to get there because there is always because there has been precedents in that area. It is also time saving because when they listen to the facts and they realize that there's a precedent there, they just put the principle and then they come up with the decision. It is not now that they are going to deliberate and come up with a new decision. No. It also offers opportunity to develop a new law. So if they come up with a decision, when there's a development of a new law, it may be incorporated in that particular legislature. And one thing that I want you to also know is that when it comes to judge-made laws, for example, decisions made by the Superior Court of Judicature, it is also termed as a law in Ghana. So every decision that they make, it is a law in Ghana. So every decision taken by the Superior Court of Judicature in Ghana here becomes a law. Whether it is a declaration, whether it is the interpretation of a law, when they come up with a decision and they interpret, those principles become law in Ghana and they are binding. Those principles become law and they are binding. Now, we move on to the disadvantages of judicial precedents. One, we have rigidity. It is very rigid. So far as the case is similar, you have to apply it to it. Sometimes there may be some twists and turns that you may want some flexibility to do something, but because the principles are similar, you might have to apply it to it. Two, it can be complex because it may be difficult to differentiate between the ratio disadendi and then the obiter dictum. So it may be difficult to separate ratio disadendi from the obiter dictum. Next, it's slow growth. Slow growth, meaning that if we have a principle, unless it is amended by a court higher than the court that came up with that decision, the case or the principles are going to remain same until it moves up to the higher court and the higher court comes up with a different or a modified principle. Also, mistakes can easily be perpetuated. That means that if the higher court comes up with a decision and it makes a mistake, even if it is for 10 years and it has not been modified, that mistake will be perpetuated in all cases by the lower courts. That mistake will be perpetuated by in all cases by the lower court for the next 10 years before it can go up and then it can be modified. So it is easy for mistakes to be perpetuated in other similar cases. Now we move on to the Ghana legal system. The Ghana legal system. And then we are going to look at briefly the court structure in Ghana. Briefly, the court structure in Ghana. Now, Ghana inherited a common law system developed in the Middle Ages by the Anglo-Saxons. Here we are talking about the British. Now, Ghana, like all other countries colonized by the British, practiced the common law system, which gives primacy to judicial decisions and sets down as precedents to guide the resolution of later cases with similar facts. Our courts still rely on the common law and the court of equity or the laws of equity, and then they supplement it with statutory provisions. So we still rely, as I've already mentioned, there are some areas that we don't even have a full-fledged law governing that area, and we still rely on the common law. And even the ones that we have a full-fledged act in that area, we sometimes even supplement it with the rules of common law and the laws of equity. Now, the sources of law in Ghana. In Ghana, these are the 5 sources of law in Ghana. If there is any law that is not found here, then that law should not be applicable in Ghana. That law should not be applicable in Ghana. So the first one is the 1992 Constitution. Let me even type it there. It is not just the Constitution, it is the 1992 Constitution. Ghana, we've had 4 republics, and each republic came up with its own laws. So when we talk about the Constitution, we are talking about the 1992 Constitution. Now, this is the supreme law of the land. Every law that contradicts the 1992 Constitution shall be repealed. So if there is any law being practiced in Ghana that goes against the 1992 Constitution, then that law should be repealed in Ghana, or that law should not have any standard. So you see that sometimes when Parliament is coming up with a law, some people challenge those laws in the Supreme Court. The Supreme Court can decide that it is against the constitution. And if the Supreme Court decides that it is against the constitution, then that law will never be passed in Ghana. If the Supreme Court decides that that law is against the 1992 constitution, then that law, to the provision, to the extent of the contrasting with the 1992 constitution, will not be passed in Ghana. And even if the law has been passed already, that provision will cease to work. And if it is the whole law that contradicts, then that whole law is not going to work. I remember the Anti-LGBTQ Act. It is still at the Supreme Court. I don't know whether they will revisit it again. Warriors, I'm coming. I don't know whether they will revisit it again. All right, Warriors, you can speak.
So that was what I was going to ask about the anti-LGBT. So
Yes.
is it that
So
even if you can change it in the Supreme Court?
All right. So the thing is, Ghana's law has been heavily influenced by one, the common law, two, our customary laws. So these two things has heavily influenced our laws. So sometimes there's some laws that you see that you definitely see that it is coming from the common law. And there are some laws that when you see, you realize that it is because of our custom, it is because of our tradition. That is why we came up with those laws. Now, if you go to the Muslim countries, where if you steal something, they cut your hands. If you rape someone, or even if you're a woman and then you commit fornication or adultery, you are being lashed in the town square. You can see that their law is heavily influenced by their Quran, or heavily influenced by their Islamic practices. So same way in Ghana here, our laws are being influenced by the common law, that is the laws in the British that we inherited, and then our customary laws. Now, depending on the arguments made in court is going to decide whether the anti-LGBTQ law should be passed or should not be passed. Now, they've made it a human rights issue. The human rights issue is that if I am a human being and I can decide whatever to do with my body, if I decide to have sex with anybody, it is no one's business. If they decide to make it a human rights issue and the Supreme Court agrees that the anti-LGBTQ is going to restrict the human rights of people, then that anti-LGBT act is never going to pass. That is one. Two, if there's an argument that it is not that LGBTQ is not compatible with our customary laws, because every jurisdiction has its own customary before even the influx of the formal system. So if we're able to argue that Ghana, we have three main religions: Christians, Muslims, even the traditionalists, and all of us as Christians, Muslims, traditionalists. I know that there are some people who can be atheists. That is fair enough. But heavily influenced by these, we can agree that it is not compatible with our way of life. So if it is not compatible with our way of life, it doesn't matter, then anti-LGBTQ is going to stand. And if it stands, that will mean that they are going to criminalize gay activities in Ghana. So it is now up to the Supreme Court to decide. Now, our fundamental human rights are enshrined in the 1992 Constitution. So it is up to the Supreme Court to actually decide as to whether, one, it is true that the anti-LGBTQ impedes on the rights and then it contradicts the 1992 Constitution, or whether it doesn't and then it should pass and then we should criminalize same-sex activities in Ghana. So we are waiting on the Supreme Court. All right, so Idris, is it clear? All right. I'm going to take the silence as a yes.
It's clear.
All right.
So,
All right. So I'm just saying that
the former finance minister case, the extradition matters. So how are you going to relate it to?
You see, that one is not a law, like it's not like a source of law. This is an international law. So because they are in a different, the laws applicable may be different. So the extradition, you may have an extradition treaty with a country. However, if they've gone against a rule there, then they must deal with them there before they come back here. But My opinion is that this is mainly political. This is mainly political because, in my opinion, if it was a normal human being like you and I, like even one day we'll not come in and then we will be in Ghana. But definitely, they said he has health issues, he has this, he has that. So all of those things must be considered. All right, let's not turn this into a political issue. Let's move on. Now, all I'm saying is that the 1992 Constitution is the Supreme Court of the land, and no law should come against the 1992 Constitution. If there is a law that comes against the 1992 Constitution, that law ceases to hold. And it is only the Supreme Court who can decide whether a law comes against the 1992 Constitution or it doesn't come against the 1992 Constitution. Because only the Supreme Court has the power to interpret the 1992 Constitution. So if there is an interpretation in the 1992 Constitution that is needed, we need to go straight to the Supreme Court. We have to skip all courts and go straight to the Supreme Court. The higher court cannot interpret the 1992 Constitution. The Court of Appeal cannot interpret the 1992 Constitution. Only the Supreme Court can interpret the 1992 Constitution. All right, and they can decide which laws contradict the 1992 Constitution and which laws do not contradict the 1992 Constitution. Now, before a section or a provision in the 1992 Constitution is amended, we need a referendum. That means that there need to be a vote in Parliament, and also there need to be a vote among Ghanaians before there can be an amendment. Now, the Ghana's 1992 Constitution is relatively new, so there has been no amendment so far. Ghana's 1992 Constitution is relatively new, so there has been no amendment so far. I think this current government was trying to introduce some amendments. I think they are still doing it, but people are also against some of the decisions as to which ones are relevant and which ones are not relevant. I think, you can speak.
So it has finished. Is it not the report of the Constitutional Review Committee?
Oh yeah, the report is just a report. But for there to be an actual amendment of the 1992 Constitution, there must be a referendum. So the report can be like, okay, so we should change this one, we should change this one, we should change this one, we should change this one. That is fair. But for there to be an actual change, there must be a referendum in Parliament, and also we have to vote on it. So I think one of the I don't know whether it's a provision or a report that caused a lot of stir is the third term. The third term that president should have. That was, I think that was a common one, and then it came out. And from what I saw, I believe Ghanaians were against it. However, it might just be my algorithm. Some people might also be truly into it. There are some people who are not on social media, but they are truly into it. So you're not going to hear their response. And there's some people that they may not be featured on the television or radio. So they may be into it, but you may not even know. But from what I gathered, from what I've heard, I feel like people are not into it. But like I said, it can be that people may be into it, but they've not voiced it out, or they are not featured. Okay, so I think Albert's hand is up. Albert, you have a question or contribution?
Yes, sir. Concerning the LGBTQ plus, it seems the whole nation have interest on that. Why should we allow only the Supreme Court to decide for the whole nation? Meanwhile, we can also hold a referendum to know our interests.
Now, because one, the LGBTQ is not enshrined in the 1982 Constitution explicitly. So if you are bringing a bill for LGBTQ, it is not amending the 1992 Constitution. That is one. Two, it is an issue of human rights. So we are coming to decide on whether it impedes on human rights or not. Mind you, the three arms of government are there to represent us. We vote for our MPs to go and make the laws. So the MPs have made a bill. That's the Anti-LGBTQ Act. And before it was even presented by the president, someone took it to court. Now, they have to look at the merits and the demerits they have practiced law for a very long time. When we are doing the court structure, you realize that the Supreme Court, you need 15 years practicing as a lawyer before you can even be considered as a Supreme Court justice. So when you look at that, they've practiced law in what? Far more than us. So they can understand how the law came about, whether it should go against the human rights or it doesn't go against the human rights. So they are just representatives of us who are there making the decisions for us. However, we can show our displeasure by, how should I put it, by demonstrating. So at other sides of the country, we've even seen demonstrations in Ghana here, but other sides of the world, when the Supreme Court comes up with a decision that they disagree with, or when there is a bill in Parliament that they disagree with, they protest the bill and they also protest the decisions. And the protest can lead to a review of that decision. Like as at now, they are the only people who can do that for us. All right. Now, like I said, Ghana's 1992 constitution is relatively new. So we don't have a lot of amendments. However, when it comes to the US, they've had a lot of amendments. I think this is their 47th president. In Ghana, this is, I don't know whether I should count JM twice. But we've had 1, 2, 3, 4. I think this is like our 5th president, if you are counting him twice, and our 6th president in this republic. But in the US, they've had about, I think, 46 or 47 presidents. That's how old they are. So they've had a lot of amendments. So I believe that one of the reasons why there isn't a lot of amendments is that they started it and they amended it to the correct time. So Ghana, we just copied, not just copied, but we just looked at them and then we imported the good things. So for example, in the US, when they started, the presidents didn't have a 2-term. The presidents could go as long as they wanted, but they realized that that could cause a lot of problems. So they limited the president's term to 2 terms. So after 2 terms, you can no longer become president. So they started from a lot of the president doesn't have a restricted term, and then it's moved on to 2 terms. And since then, they've not amended that again. However, in Ghana here, in 1992, before we were even writing our constitution, they had already gone through that and they have now restricted it to 2 terms. So we just imported that and then we fixed that president shouldn't go more than 2 terms. So that is what we have in our constitution. That's what we have in our constitution. So I can say that mainly we've been inspired by a lot of developed countries, and then we've just imported a good part into it. That's why we've not reviewed a lot. But some people also believe that yes, it needs to be reviewed. Now, anyone who tries to abrogate the 1992 Constitution has committed high treason. Everyone who tries to abrogate, when we say abrogate, who tries to overturn the 1992 Constitution commits high treason, which is punishable by death. So if you want to, it's still a coup which overturns the 1992 Constitution, you've committed a high treason. And this high treason is punishable by death. Now, even though Ghana has done away with the capital punishment, because the capital punishment has some disadvantages. Sometimes you would think someone has committed a crime, and then there's a capital punishment, the person is killed. And after you realize that the person wasn't the one who did it, you cannot bring the person back to life. However, if the person is serving in prison and you realize that the person didn't do it, you can now bring the person out of prison. So this led to a lot of reforms, and then most countries have adopted the abolition of the capital punishment. But even in the US, because the US is a very big country, and then they practice the federal system, and then each state can have its own laws. Some also stick to the capital punishment. But Ghana here, our regions are very small, so we have one central government. So because we have one central government, every law binds every region in Ghana. So in Ghana here, we've abolished the capital punishment. However, it is still in the 1992 Constitution. So we will need an amendment in the 1992 Constitution to make sure that high treason doesn't attract death. That means that all other crimes that attracted death has been life imprisonment. However, if you commit high treason, because that part has not been amended in the 1992 Constitution, it still attracts a death penalty. So anyone who is planning a coup should just should advise themselves, because if you are arrested or if you are caught, their crime is high treason, and then the punishment is death. All right. Now let's move on to enactment by punishment by Parliament. Now, the Constitution has delegated its law-making rules or its law-making ability to the Parliament. So the Constitution is one book. That book cannot govern the whole country. So it has now given the right to Parliament for Parliament to enact subsequent legislatures. So Parliament is tasked with the obligation to enact subsequent legislatures. Now, the only caveat is that every rule that Parliament comes out with should not contradict the 1992 Constitution. Every rule that the Parliament comes out with should not contradict the 1992 Constitution. If you think it contradicts the 1992 Constitution, then the court that can go and dispute that is the Supreme Court. The court that can go to dispute that is the Supreme Court. Now, they come up with acts of government or acts of parliament. So there are a lot of examples of acts of parliament that if you are being asked, you can just come up with them. Most of the acts that I gave in the business law applies under the Act of Parliament. So all acts that were given after the 1992 Constitution are all examples of the Acts of Parliament that we have in Ghana. Now, next, we have orders, rules, regulations that are passed by people of authority who have been given this authority by the Constitution. So apart from the Parliament, other people can come up with laws. Apart from Parliament, other people can come up with laws. And these people have been given the rights by the Constitution. For example, the president. We have other ministers. We have heads of agencies, heads of authorities. They can all come up with orders, rules, and regulations. Orders, rules, and regulations. Now, usually these rules must be laid before Parliament. These rules must be laid before Parliament. And if Parliament does not go against the law or does not reject the law, then it becomes a law in Ghana. So, for example, sometimes, like this laying before Parliament, sometimes if certain rules apply or certain circumstances apply, the one who is coming up with the rule need not lay it before Parliament. He can just bring it up and it becomes a law. So an example was the COVID-19, where the president just came out and just said all pubs should close, all this should be that. Everything that he said was complied with. So in cases of emergency, there can be rules that are not laid before Parliament. However, usually these rules must be laid before Parliament. These rules must be laid before Parliament. Now, another example is the Minister of Finance. Anytime that he reads the budget, he brings up new laws. Every time that he reads the budget, he brings out new laws. So the previous government, I like using this as an example. The previous government, when they read their budget, they introduced the e-levy. They introduced the e-levy. And as the budget was approved by Parliament, the e-levy was also approved. So the ministers can also come up with rules. The ministers can also come up with laws. Electoral Commission, every time that we are going to vote, they come up with rules. Now, these rules can take the form of CI, EI, or LI. Or the constitution instruments, I'm hearing some sound. All right. So we have the constitution instrument, the legislative instruments, and then the executive instruments. These are what these people come up with. And these things are usually known as the subsequent legislature, subsequent or subsidiary legislature. That means that it is not made by Parliament, but it is made by people, other people who have been given authority by the Constitution. So Electoral Commission can come up with an instrument. All of these things are rules that bind us. Even administrative laws. We have other agencies under all these ministries who can also come up with rules and regulations. For example, the Food and Drugs Authority, when they make a rule within Food and Drugs Authority or within the food with food and drugs related issues, It is binding on everyone who is in that sector. So all of these people have been given the rights to come up with laws, and these laws must be placed before Parliament. And if it is not rejected, it is binding as rules and regulations. So all of these people can also come up with other rules and regulations that is going to bind us. Next, go to existing laws. Now, these are laws that existed before the 1992 Constitution. So every law that existed in Ghana before the 1992 Constitution is known as an existing law. Every law that existed. So every law that has a year before 1992 is known as an existing law in Ghana. Now, the existing law also, one, should not contradict the 1992 Constitution, should not have a new enactment by Parliament to replace it. That means that a law ceases to exist if the Parliament has come up with a new law to replace it. However, if it does not contradict the 1992 Constitution or there is no subsequent legislation to replace it, then that becomes an existing law. So, for example, the Contract Act 1960 is an existing law. The Partnership Act, I think 1962 or so, yeah, 1962 is an existing law. We also have this, the Sale of Goods Act. All of these acts are existing laws because they came before the 1992 Constitution. However, if those laws has been replaced, a recent example, 2019, is not even that recent. 2019, the Companies Act was replaced. The Companies Act was 1963. So before 2019, the Companies Act was an existing law. But in 2019, they replaced the Companies Act with a new act, Act 992. So now the Companies Act of 1963 has ceased to be an existing law, and the new law is now an act of Parliament. So we are saying that these existing laws should not contradict the 1992 Constitution, and also should not be replaced by a new enactment by Parliament. Now, sometimes there may be some amendments or some additions to these acts. There may be some amendments or some additions to this act. Now, these amendments or additions do not replace them. They just add up to it. So you see that it will be an existing law, and then they will say that as amended by, then they will add those things to it. So it is still a law that is existing. However, it has been amended by some new laws. However, it has been amended by some new laws. So unless it is entirely replaced, it doesn't cease to be an existing law. Unless Parliament sees it fit that everything then needs to be replaced with a new act, then it doesn't cease to be an existing law. Maybe it's just one part that needs to be tweaked a little bit, or they need to add certain things because of how things are moving, because we are in a new era and then new things are coming. They can tweak it a little bit and then they can just add an amendment. That doesn't make it not be an existing law. However, if they change it and they replace it with a new act, then that ceases to be an existing law. And lastly, we have the common law. Now, the common law that we have in the Constitution is very broad. It includes the common law that we inherited from the British. So the common law that you see, it includes the common law that we inherited from the British. And it also includes the laws of equity, and it includes the customary laws, and it also includes subsequent judicial decisions that we have in Ghana. So all other subsequent decisions by the Superior Court of Judicature also forms part of this common law. So the common law that we have in the Constitution has been explained as one, the common laws that we inherited from the British, the laws of equity, customary laws, and also subsequent judicial decisions that we have from the Superior Court of Judicature. Now, the only caveat here is also that one, the common law principle should not contradict either the 1992 Constitution or any enactment by Parliament. So if there is a Ghanaian law that the common law contradicts with, then the common law ceases to be a law in Ghana. Same thing applies to the laws of equity. Also, when it comes to customary laws, we are looking at customary laws that do not contradict the 1992 Constitution and also do not contradict any enactment by Parliament. And when it comes to the customary law, one important part is the human rights issues. So there are some customary laws that are being upheld by the law, and there's some customary laws that are not upheld. So, for example, we can both attest to the fact that FGM, female genital mutilation, is cruel and it what impedes on the right of women. So, such a customary act is not going to be recognized by the law because it contradicts the 1992 Constitution. But we have other customary laws that are accepted by the 1992 Constitution or can be practiced in an area. Now, mind you, the customary law differs from area to area. You know that not all everyone perform the female genital mutilation. So the customary laws is actually laws that govern an area. And the customary law, before it can be accepted and practiced in this modern day Ghana, it should not contradict the 1992 Constitution, or it should not contradict any enactment by Parliament. And the key word or the most important part is looking at the human rights issues. The key part is looking at the human rights issues. All right, so these are the sources of laws that we have in Ghana. These are the sources of laws that we have in Ghana. So anytime that you are being asked to list the sources of laws that we have in Ghana, these are them. Now we also go to the structure of the superior courts or structure of the court system that we have in Ghana. First, we have the Supreme Court, second, Court of Appeal, and then third, we have the High Court, as well as the regional tribunals. Now, these three form the Superior Court of Judicature. So if you are being asked to list the courts, the Superior Court of Judicature, they are made up of one, the Supreme Court, two, the Court of Appeal, and three, the High Court. They in brackets, the Fast Track High Court, Commercial Division, Land Division, they are all divisions in the High Court. So they are just divisions in the High Court. However, they all come together and they form the High Court. So when you go to the High Court, they have these divisions. And then if it is a commercial matter, you go there. If it's a land matter, you go here. If it's a human rights issue, you have a place that you would go. They just separate it so that it will be easier to handle cases, but they all form the High Court. So these are the Superior Court of Judicature. So we have the Supreme Court, Court of Appeal, and then the regional tribunals. Sorry, the Court of Appeal and High Court / regional tribunals. Now, the regional tribunals are in the Constitution. However, they do not have operation. Like, they are not highly operational as the High Court that we have in Ghana. They have similar roles of the High Court. However, there are some decisions or there are some issues that I cannot send there. And then I don't really remember the last time that I saw a regional tribunal. So usually we deal with the High Courts. So let's go through them simply and then we can move on. So the Supreme Court is the highest court of the land. Supreme Court, highest court of the land. Before you can become a Supreme Court justice, you must have 15 years. 15 years in standing as a good lawyer, and then you must have high moral character and proven integrity. The Supreme Court, when they are seated, they sit in fives. But if it's a review jurisdiction, a review is where they want to revisit a case that they've already dealt with. A review jurisdiction, then we are saying that they sit in 7. Now, they always sit in odd numbers. So when you go to court, there's no draw. It's either a win or a lose. They sit in odd numbers, so that's always there will be a winner and a loser. All right. So some jurisdiction of the Supreme Court include 1, interpretation of the 1992 Constitution. They are the only court that can interpret the 1992 Constitution. 2, they also have production of official documents in court. So now, if there's an official document or an official government document and you want to produce it, they would have to see whether it is a threat to national security or not before they can give it the go-ahead to come up with that document or to make public that document. They also have a review jurisdiction that I've already mentioned. So the review jurisdiction is where they are allowed to go through a decision that they've made. Now, apart from the Supreme Court, no other court has a review jurisdiction. No other court has a review jurisdiction. That means that if you're not satisfied with the case, you move on to the higher court. But because they are the highest court, they are afforded a review jurisdiction. That means that they can go back and sit on a case that they've decided to see whether they are going to depart from it or they are going to stay with it. However, no other court can sit on a case to decide that. If there's any dispute, you need to move on to a higher court. So the difference between a review and an appeal is that an appeal, you appeal in a higher court. But with a review, the Supreme Court can sit on the case that it has already sat on to see whether it is going to depart from the decision or not. Now, they also have supervisory jurisdiction. This is where they supervise all other courts below them. So they can supervise all other courts below them, and they can also supervise the other organs and the other agencies in Ghana. So I'm going to mention this. I'm not sure these are in the book, but just for understanding, I'm just going to mention these. Let's see. All right, so they are not in it, but I'm just going to mention this quickly, and then we are going to move on. Now, they also have the supervisory jurisdiction. That gives them the authority to supervise all the courts below them and also supervise the parliament, the executive, and all other agencies. That is why, so when I mentioned that if there is an issue in the parliament that and parliament has come up with a law and you think the law contradicts, you send them to the Supreme Court. That is because the Supreme Court has to supervise them. The Supreme Court supervises all of these people. So examples of these orders that they give while they are supervising include one, the certiorari, two, the okay, so
Okay, so the Court of Appeal. The
and
Court
this is
of
an example.
Appeal,
So
is it a
yeah,
huh?
is it what?
The Court of Appeal, is it a department in the Supreme Court, or it also have its location?
It it's a yeah, yeah.
It's
So
a
I think
separate court.
the location, last time I checked, I think they have the same location. Yeah.
Uh,
However,
so it's
the
department
Court of
under
Appeal is different from
in
the
the,
Supreme
the
Court.
Supreme Court.
A sitting in the Court of Appeal is not the same as a sitting. No, no, no. It's a separate court.
The Court
It's
of
a whole
Appeal.
separate court.
Yeah.
But just that the location is the same.
Okay. If I thought it's in the same Supreme Court, but maybe in separate department.
Just that the location is the same. Is it clear? Is my network still on?
It's breaking.
I think I went off again. Hello, can you hear me?
Sir, please, your network
You are live.
is breaking.
Yes. No problem.
Hello. Yeah, so as I was saying, it's not a part of the Supreme Court. They just happen to be the same location. However, it's a separate court on its own.
Okay, sir.
Hello, sir.
Is it okay now or is it still breaking?
Sir, please, we are not hearing you.
It's not fading now.
Hello, is it okay now?
No, sir. It's not. It's not clear.
Hello, if it's okay,
Say it is not.
Yeah, give me a thumb. Yeah, it's okay now.
No, sir, we can't hear you. It's still breaking.
If it's okay, can you give me a thumbs up?
Yeah, it's okay. Let's move on.
Hello, if it's okay, can you give me a thumbs up? All right, okay. So as I was addressing the question, all I'm saying,
Sir, please, it's not okay. I can't hear you.
please don't let them come. I'm trying to switch my network. So I'm back. Before I even join, some people's hands were up. So if they had a question, they can just ask the question before I move on. All right. But to confirm that everyone can hear me, can I please get a thumbs up? A thumbs up to show that everyone can hear me. All right. So as I was saying, the Supreme Court has some supervisory jurisdictions, and based on that, the lower courts, and they can also supervise all other agencies as well. So while they are doing that, they can issue a certiorari, which is a question order. Briefly, this is just for understanding purposes. A question order is where they issue an order to cancel a decision made just because they believe that the decision has not been taken properly or the courts didn't have the right to adjudicate that particular decision. So there may be some procedure breaches that they use. Maybe they didn't go through the right process. So all of these can be reasons why the Supreme Court can issue a question order. The Latin word is a certiorari, question order to cancel a decision made by a lower court. They can also issue a mandatory order. A mandatory order. Now, this mandatory order is to mandate a public officer or any other person to make sure that they do what they are supposed to do as their job. So sometimes if somebody doesn't want to do something, maybe you go to the DVLA, you go to anywhere and you believe that they don't want to do their job for you, you can go to the Supreme Court and the Supreme Court can issue a mandatory order. They can also issue a prohibiting order. That means that it is to stop either a court or an agency from doing what they are not supposed to do. So, for example, they are now about to hear a case, but the case is not in their jurisdiction. The Supreme Court can issue an order to stop them from listening to that case. So that order is known as a prohibiting order. So a quashing order usually comes after the decision has been made, and a prohibiting order comes before the decision is made. So they give the prohibiting order before the mistake is being made. Now we have other writs or other orders such as the quo warranto, which questions the authority by which someone does something or by which someone occupies a position. And we also have the, I think, habeas corpus, which means produce the body. This one is usually issued to law enforcement agents to make sure that someone is not detained more than the appropriate hours that the person is to be detained. So if you detain someone, you must have a cause or a reason for the detainment. If you don't, then the court is going to issue a habeas corpus. You bring the person to court, produce the body. Here, people usually confuse producing the body with a dead body. We mean someone who's alive, just produce the person in court. And if you're able to provide evidence to substantiate why you still have to keep the person in jail, the court is going to allow you. However, if you're not able to provide any substantial evidence or any substantial claim, then the court will have to let the person go. So these are supervisory jurisdictions by the Supreme Court. So what the Supreme Court can do, anytime I hear jurisdiction, it is what the Supreme Court can do. So these are the jurisdictions of the Supreme Court. Now, the supervisory jurisdiction is also held by the High Court. So in Ghana, only two courts have supervisory jurisdiction. We have the High Court and the Supreme Court. These are the two courts. And everything that I mentioned for the Supreme Court, the High Court has a similar jurisdiction. However, the extent of the jurisdiction is defined. So not, even though they have similar jurisdictions, not everything that the Supreme Court can do that the High Court can do. For example, when it comes to Parliament enacting laws in excess of their powers or in excess of it contradicting the Constitution, the High Court cannot adjudicate such a case, even though it has supervisory jurisdiction. The level of supervisory jurisdiction is not up to them to determine whether a law contradicts the 1982 Constitution or not. So usually they have similar jurisdictions when it comes to the supervisory jurisdiction. However, the extent of the application, the Supreme Court has over almost every organ in Ghana or every organ or agency in Ghana, but the supervisory jurisdiction of the High Court is limited to the courts below them and also limited to the extent of the other agencies that it can cover. Now, even though I have moved to the High Court, I said this because when I get to the High Court and I mention the supervisory jurisdiction, I don't repeat myself. That's why I'm saying that they both share supervisory jurisdiction. Now, one thing that also makes students confused is that when we say that the Supreme Court is the final court of appeal. Now, mind you, we have a court of appeal, but the Supreme Court is a final court of appeal. When we say a final court of appeal, it is just an attribute to the Supreme Court. But the Court of Appeal is actually the name of the court. Now, distinguishing the final Court of Appeal, this means that it is the final court that can appeal a case. In Ghana here, if you appeal to the Supreme Court and you don't get the decision that you want, you cannot appeal to any further court in Ghana again. That is why it is being dubbed the final Court of Appeal. So don't get it confused. We have the Court of Appeal. That is where it can hear appeals. But the Supreme Court is the final Court of Appeal in Ghana. All right, so this is just a summary of the Supreme Court. Now let's move on to the Court of Appeal. Now the Court of Appeal, when you want to become a justice of the Court of Appeal, you must have 12 years experience. 12 years experience. Now the high moral character and proven integrity, all other judges must have it. All other justices must have it. But it is the years that usually changes as to what you qualify to be. So the Court of Appeal, you must have at least 12 years experience standing as a judge, as a lawyer. Now, the Court of Appeal, the main jurisdiction of the Court of Appeal is to hear appeals. The main jurisdiction of the Court of Appeal is to hear appeals. That means that it doesn't have an original jurisdiction. Original means that they do not have the power to hear a case in the first instance. So their main jurisdiction is just to hear appeals from the High Court and sometimes from the Court of and sometimes from the Circuit Court. That is their main jurisdiction, to hear appeals. Now, when it comes to the High Court, for you to become a High Court justice, you must have 10 years, and definitely you must have high moral character and proven integrity. Now, the High Court can hear virtually every case, unless cases that has only been designated to the Supreme Court. So if there's a case that has not been specifically designated to the Supreme Court, all those cases can go to the High Court. So unless a case has been specifically designated to the Supreme Court, those cases can go to the High Court. Now, the High Court also has original jurisdiction on human rights issues. That means that when you have a human rights issue, it must start from the High Court before it can progress on and go to the Supreme Court. So they have original jurisdiction over human rights issues. Now, when the High Court is sitting, they can either sit with a judge and a jury, a judge and assessors, or 3 justices. Sorry, a justice. So in the Superior Court of Judicature, the people who man those, or the people who sit on the benches, are known as justices. So we have a Supreme Court justice, a Court of Appeal justice, and then a High Court justice. A Supreme Court justice, a Court of Appeal justice, and then a High Court justice. A Circuit Court is known as a Circuit Court judge, and then a District Court is known as a magistrate. So these are just names and semantics. All right. Now, so like I've mentioned, the High Court, they can sit in this. Now, at any point in time, the justices of the Supreme Court should not be less than 9. Should not be less than 9. And at any point in time, the justices of the Court of Appeal should also not be less than 10. And at any point in time also, the justices of the High Court should not be less than 20. Anytime that they fall below that, the president must appoint new justices for them to be approved by the parliament. Now let's go to the lower courts. The lower courts includes the Circuit Courts, District Court, and then the family tribunals, and then the juvenile court. Now they are being placed side by side because they usually occur in the same court. However, anytime that they are sitting, they tell them the kind of court that they are sitting. So you can have a juvenile court sitting in a district court. However, the person that we are dealing with is someone who is not more than 18 years old. So the building can be a district court, but it can act as a family tribunal, or it can also act as a juvenile court. But in every setting, they make an attempt to let you know the type of setting that is happening there. Now, the Circuit Court. The Circuit Court also, before you become a justice, as a judge of the Circuit Court, you must not you must have experience as a lawyer of not less than 5 years. Not less than 5 years. Now, the Circuit Court is limited in some of the things that it can do and some of the things that it cannot do. Now, for example, when it comes to the Circuit Court, when it comes to criminal issues, they cannot handle treason and high treason. They cannot handle treason and high treason. I've already mentioned treason. Why I mentioned that it is where you try and then abrogate the 1992 Constitution. Where you try and abrogate the 1992 Constitution. Now, if you also try and then you try to overthrow any arm of government, that one falls under treason. So if there is a treason and a high treason, the Circuit Court cannot handle it. So with criminal issues, treason and high treason, the Circuit Court cannot handle it. And then when it comes to civil issues, if the issue is more than 2 million Ghana cedis, if the issue is more than 2 million Ghana cedis, then we are saying that that issue cannot be handled by the Circuit Court. Now, in your books, I've seen that the amounts are there. However, the amount has been updated. So I want you to take very quick notice of that. I think in the book, it was like 200,000 or so. Let me see. Now the Circuit Court was 50,000, and then the District Court is 20,000. but that has been amended. And now, if you want to send a case to the circuit court, the circuit court, the amount should not be more than 2 million Ghana cedis. If it is more than 2 million Ghana cedis, then it goes straight to the High Court. It goes straight to the High Court. So they can handle civil disputes. You've already discussed what civil disputes are: tenancy agreement, contracts, land issues, every amount. The amount should not just be more than 2 million Ghana cedis. If the amount is no more than 2 million Ghana cedis, it can be handled by the circuit court. But if it is more than 2 million Ghana cedis, then it has to move to the High Court. So the criminal issues, they cannot handle treason and high treason, and they cannot also handle cases of indictment, that is serious crimes, and also offenses punishable by death. Circuit courts cannot handle that. Circuit courts, criminal issues, they cannot handle treason, high treason. They can also handle indictable cases and also cases punishable by death. Circuit courts cannot handle that. When it comes to civil issues, the amount that they can handle should not be more than 2 million Ghana cedis. The amount that they can handle should not be more than 2 million Ghana cedis. Now to the district court. The district court also, when it comes to criminal issues, the district court, when it comes to criminal issues, they cannot handle issues that the punishment exceeds 2 years. That the punishment exceeds 2 years. Also, they cannot handle issues where the punishment is more than 500 penalty units. So these are criminal issues. These are criminal issues. Now, when it comes to civil issues, they cannot handle issues if the amount is more than 500,000 Ghana cedis. 500,000 Ghana cedis. So if an amount is more than 500,000 Ghana cedis, the district courts cannot handle it. Now, when it comes to the juvenile courts, they handle cases of infants who have not attained maturity yet, infants who are less than 18 years. The family tribunals tend to resolve disputes among family members. So juvenile court is a separate court. However, it is usually had in a district court. And anytime that it is being had in a district court, the case is presented, and when the case is presented, the case should involve someone who is less than 18 years old. Someone who is less than 18 years old. All right. So we move on to the next one, which is the alternative dispute resolution. Alternative dispute resolution. Now, we've talked about the court system, and we've talked about the cases that the court can handle and the cases that each court can handle and the cases that each court cannot handle. Now, as businessmen and women, we are being advised that litigation that is going to court can be harmful to our business relationships. So there has been an encouragement that we should use ADR, that is alternative dispute resolution. We should try and resolve cases outside of court. And if we do that, that is going to help promote our business relationships. So even though we can go to court, there has been the advice that going down to the ADR is better than going to court, because courts can only give a win-lose situation. Whilst if you sit down to talk among yourself or you have a third party to moderate for you, it can come up with a mutually beneficial result. So usually people promulgate, or it has been promulgated in the business sector, that we should resort to alternative dispute resolution rather than always going by litigation or always going to court. Now, the definition of ADR, or alternative dispute resolution, is a procedure for settling disputes without litigation. Without litigation. So this is where we settle disputes without going to court. Now, even if you bring it outside of the business sector, even if you want to localize it, sometimes when marital couples get issued, they can sit down and they can decide to talk about the issue themselves. They can also involve the elders in their family, those who are known as Ebusuapanyini, to help them resolve the issue. They can even go to a counselor or even go to their pastor. Sometimes their pastors also double as their counselors, their marriage counselors. So all of these are aspects of ADR, alternative dispute resolution, rather than settling the dispute in court. Rather than settling the dispute in court. Now, ADR provides flexible and less formal methods of dispute resolution. So we have a lot of types of ADR. We have negotiation, we have mediation, conciliation, we have arbitration, we have mini trials, we have early neutral evaluation, we have settlement conference, we have a combination of mediation and arbitration, and also we have renting a judge where you can rent a judge to help you resolve your dispute. However, we are going to deal with the three main ones. We're going to deal with the three main ones. Now, the three main ones include negotiation, mediation, and arbitration. Now, negotiation is where the two parties come together to resolve their dispute without the introduction of a third party. So the informal example that I gave you, where the married couples will come together to resolve the dispute by themselves, that can be seen as a negotiation. They are resolving the dispute without a third party present. And then with the mediation, there is a third party, but the third party does not come up with a decision for them. The third party will suggest solutions and they will be the people to accept such solutions. So they can decide to either accept it or reject it. So the third party will help them come up with the solution, but the third party does not give the solutions to them. And then we go to arbitration. Now with arbitration is similar to a court system, but it is an informal system because with arbitration, the third party sitting there will come up with a decision which is binding on the parties. So the third party will come up with a decision which is binding on the parties. This is what I'm coming. All right. So as I was saying, with arbitration, there are third parties, and then the third parties will come up with a decision which is binding on you. The third parties will come up with a decision which is binding on you. However, if you are going for an arbitration process, you are the one who choose to go for the arbitration process. No one will force you. But if you choose to go through the arbitration process and there's a decision, the decision is now binding on you. So it is known as an informal trial, something that looks like a trial, but it doesn't have all the court rights, the mechanics of a court. But the system is set up like a court, but it doesn't have the inflexibilities of a court. So these are the main ADR mechanisms. Mediation, just the two parties. Mediation, there's a third party who just helps them come up with a decision. And in arbitration, the third party will come up with a decision which is binding on the parties. All right, Idrisu. Idrisu, your hand is up.
Okay, sir. Assuming you have a land, let's say, dispute between you and your brother, and maybe you want a chief for him to settle the matter. Is it mediation or arbitration?
Now, usually, before our formalized court system, the chiefs were the judge, the jury, and the executioner. They came up with decision for us. So they still have that system. So the chiefs also have their own judicial system that leads to the Supreme Court. So it will depend on how you want the chief to do it. If you report your brother and you are called by the chief, then the decision made by the chief is binding and final. However, if you are just going to the chief to help you resolve it so that everyone will be happy, then that can be an ideal process. So the chief can be in the form of an elder who is helping you resolve it. And okay, so if you want the land, why don't you divide the land into two, take half, and this one will take half. However, if you approach it like you are approaching litigation, you report, and then he is summoned by the chief palace, then the decision making is binding on you. Because the chiefs have judicial powers. Is it clear?
So what about if if the outcome is not in your favor?
If it's not in your favor, then it means that if you want to appeal, then you can appeal. But the chief's decision is final. You can appeal. I think they have their own judicial system that appears at the Supreme Court. So if you go through the systems and then you cannot see it, then you can go straight to the Supreme Court. So there's a difference. If you are picking a paramount chief, a chief itself, to adjudicate the case for you, then it can result in a judicial settlement. However, if it is a normal sitting and then let's advise ourselves and let's choose, then it means that he can just suggest ways to make sure that he brings this one down. So, for example, the decisions by Ashanti, so that I'll be Ashanti bias, or two for if there's an issue and then two for adjudicates, it is binding on the parties. However, when it comes to the chiefs, they usually deal with chieftaincy issues. So, for example, it's going through the traditional house of chiefs, we have the regional, the national house of chiefs. It's usually chieftaincy issues. But in villages, you can still have the chief acting as adjudicator and then adjudicating issues for you. All right. So if you believe that you want a judicial decision, then I don't think it would be best for you to go to the chief's palace, unless you just want an elder at the chief palace or even the chief himself to just help you resolve the dispute. But if you want a legally binding one, then I advise that you go straight to the court.
Okay.
All right. Okay, so we have these three types. We have the negotiation, mediation, and then arbitration. And all of these types has its own advantages and disadvantages. Negotiation is just the two parties there resolving it. They can be bullied. The hard negotiator can bully the soft negotiator. With mediation, you can also have a mediator who is not impartial. It all has its advantages and disadvantages. Now, with arbitration also, it acts like a court. That means that anytime that a decision is taken, it is binding on the parties. So we move on to justification of the use of ADR. Why should we use ADR? Now, it reduces cost and time. It reduces cost and time, especially if you're using negotiation. Now, I know that I have given an example using the informal setting like a marriage setting, but if it's a business setting and the two of you decide to meet and talk things out, the cost of hiring lawyers and going to court is has been cut. Also, the time that you will spend in court going through the back and forth is also cut. There are some cases that sometimes it even spends more than 10 or 20 years in court. Even some of the judges die and they are replaced and the case are still not been adjudicated. Also, ADR maintains or improves relationship. Mind you, no one wants to do business with a litigant. If you are someone who's a litigant and you are always going to court, people would not want to do business with you. So if always you are a calm person, you are always searching for ways to resolve dispute outside of court, then it can improve your relationship and it can even improve your business relationship. People would want to do business with you. If you are someone that you are suing someone, even outside the commercial realm, people will not even want to associate with you because if there's a small issue, you are sending them to court. Also, there is a satisfactory outcome. Usually, when you go for a negotiation, it can usually come up with a win-win situation. I tell you what I want, you tell me what you want, we compromise, and then everyone goes on with something. But if then one person gets something, no one gets the other thing. So, for example, the issue that you're talking about with your brother, if it's a real issue, if two guys or two people are fighting over a land, and the land is 10 acres, if they share the land 5-5 and then everyone gets something, but if they go to court and the court traces the law and traces who the land belongs to and how the land came to be, it might end up that only one person gets the 10 acres and another person gets nothing. So with ADR, there is a satisfactory outcome. Also, you can deal with your emotions. Now let's move outside the business example and let's move on to the other side. When it comes to marriage issues, you can, as in when you even go for counseling, you can cry, you can do whatever you want. However, in court, it is strictness. In court, even the way you sit, the way you even talk, sometimes you even be held in contempt. So when it goes to court, we don't care about your emotions, we don't care about how much you cry. What we care about is law and evidence. What we care about is law and evidence. But with ADR, you can even cry a little bit and then you'll be forgiven. So, for example, if a man cheats on the wife and they are adjudicating, sometimes the man can be emotional, the man can beg, the man can cry a little bit to show that he's sorry. But when it goes to court and they are fighting for divorce and they are fighting for properties, it doesn't matter even if the man breaks down crying. The law is that, or the fact of the matter is that you've cheated, it has led to a divorce, and then if the properties are being shared, the lady can take 50% of whatever you have. So with ADR, it can deal with emotions. Now, demerit of litigation. Now, this is just an extension of why we should choose ADR. So this is just a demerit, an extension of why we should choose ADR. So every demerit of litigation can be a merit for ADR. Demerits for litigation can be a merit for ADR. So it can be interchanged. Demerit of litigation, when you switch it, it is a merit for ADR. Now, cost of litigation and time, we've already mentioned that. Loss of privacy. This is where you'll be airing your dirty laundry outside. Now, remember, unless the court decides to close an issue based on reasons, the court is always open. If you have an issue, everybody can just come and sit in court and listen to your issue. Everybody can, unless with certain exceptions where the court wants to value privacy. So, for example, there's a rape victim, they don't want the stigma to stick, and they are adjudicating a rape case. They can decide to have a closed court, or they can have reasons why they have a closed court. But generally, most cases, it is an open court. And with the open court, everybody can hear whatever you are saying. Tomorrow is Monday. Tomorrow you can just walk up to any court near you, whether it is a district court, a circuit court. You can just go and sit there and listen to every case that they are adjudicating. Now, if you are someone that you are very private, you might not want your issue to come out in the open like that. So when you choose litigation, the dirty laundry may be aired outside. This is where you will hear cases that you are not supposed to hear. You would hear bedroom issues that it is not even supposed to come outside. So with litigation, we are saying that there is loss of privacy. However, if you choose to use ADR, a husband and wife choosing to go to their pastor, whatever happens there, whatever they say should stay between the husband, the wife, and the pastor. Sometimes, even if you are afraid that the pastor might use it as a sermon, the husband and wife itself, you can just sit and then you can just talk the issue or speak about the issue with each other. So we are saying that litigation, there's a loss of privacy, but with ADR, there is confidentiality and privacy. Also, absence of creative solutions. In litigation, you either win or you either lose. You win or you lose. But with ADR, we can say that, okay, so the land is 5, is 10. Why don't you take 5 and I'll take 5? Or even if you want 6 and I'll take 4, I think it's better than going to court and then one person gets 0. Also, there is little opportunity for parties to vent frustration. In courts, you don't vent frustration like that. If you say anything that the court sees as disrespectful, you would be held in contempt. Also, expertise of the decision maker. Now, mind you, sometimes the judges can specialize in certain cases, but generally the judges just learn the law and they just know the law. So when they are applying the law, they apply the law just straightforward. So there is no expert solution being given by the judge. However, if you go to a pastor who has gone to seminary school and has also done marriage counseling, when you go and the pastor is, trying to get you two together, the pastor has a way of what getting you to resolve your disputes. The pastor can come up with decisions that is going to help you because he is an expert on the decision. However, sometimes when you go to court, the judge may just be an expert on law, but may not be an expert on marriage or may not be an expert in the area that he is dealing with. So sometimes the expertise may fall short. Also, the parties have control over the system. But when it comes to litigation, the parties do not have control over the system. It is just the court. When the judge doesn't call you, you cannot talk. When the judge doesn't say stand up, you cannot stand up. When the judge doesn't excuse you, you cannot sit down. So when it comes to litigation, the parties do not have control over the process. But with ADR, the parties have control over the system. That is where you can just vent, you can just cry at any time by events. Sometimes you can even walk and then go and vent your frustration and then come back and then come and continue the case. Also, with litigation, there's a win-lose. With litigation, there's a win-lose. Generally, with ADR, there's usually a win-win situation. Now, when it comes to litigation also, the decisions are imposed, whether you like it or not. The judge has made a decision, it is final, unless you decide to go for an appeal. But when it comes to ADR, apart from certain types like arbitration, most of ADR procedures, the decisions are made by the parties themselves. Also, there's a damage to reputation. If I sue you in court and I win, there's some anonymity between the two of us, so it can damage our reputation. Even sometimes in our villages, there are some houses or some families that don't speak to a different family just because one grandfather sued their grandfather, and because of that, they are not in talking terms. So we are saying that litigation can damage relationships. Now, next, with demerits of ADR. Now, let's move to demerits of ADR. With ADR, there is no right of appeal because you make the decision yourself. Now, if you come up with a decision and you print it out and you sign, it is binding on you and you cannot appeal it because the decision was taken by you. If you take the decision yourself, why do you think you can appeal it? It is only when it comes to the arbitration that where the decision was given by the arbitrator and you are not happy about it. Even with that one, you cannot appeal the decision itself. You can appeal the circumstances surrounding the decision. So with ADR, generally or most of the time, there is no right of appeal. When it comes to the ADR also, there is fewer or absence of evidentiary or procedural protection. Here, there is no evidential or procedural protection. They can just go about it anyhow that they want it. Also, parties can walk away at any time. With ADR, you can just walk away. If you are not happy with whatever the third party is saying, you can just walk away. In court, you dare not. So this is a disadvantage of ADR. With ADR, the parties, if they are not happy with whatever is happening, you can just walk away from the table. But with litigation, you cannot. You dare not walk away from the table. Also, there's ability of a strong and powerful party to bully the other party for there to be a result that is unfair. Sometimes, especially with our certain, let me go back to the non-commercial example with the husband and the wife. The husband cheats. They wake up, they try to talk about it. Now, because maybe the wife will not be working and the husband is the sole breadwinner, the husband can bully the wife into some decisions or into an agreement that the wife, under normal circumstances, wouldn't have taken. Because if the husband is cheating, usually the wife can be like, if you cheat again, I'm walking away. But because the husband is more strong and powerful than the wife, the husband can make a statement like, if you think you cannot be in a relationship, just walk away. You, the husband cheating, he's the one even imposing the fact that if the wife thinks that she cannot be in the relationship, she should just pack her things and go to her father's house. So you see, in that relationship, the negotiation procedure will end with one powerful party bullying the other party in order to get them to have a result that is not fair to them. So even outside of the non-commercial example, we have commercial examples where two businesses, one business, because it is bigger than the other business, can bully the other business into getting a result that is not fair or then just. Now, there's also absence of opportunity to measure objectiveness of the process. Here, because they do not do things using a streamlined procedure or using a similar procedure, it is very difficult to measure whether the process was objective or not. And also, it provides the opportunity, so it does not provide the opportunity for the development of precedents. Now, if there's an ADR process on a case here, even if the next